All right, good morning, everyone. I'm Judge Corey Amanda Coffin, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak with your attorneys before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the clerk of courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that it's dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. Before I go to our sign-ins, Mr. Romero, is there anyone at Maine that needs to be called out of turn?
Judge, I'm getting that information right now, but I can give the court right now two individuals.
Okay, who are those?
First gentleman is on page 18. His name is Mr. Jordan Flick.
Okay.
And the second individual is on page 21, and his name is Jeffrey Northcutt.
Northcutt, okay.
I didn't talk to him.
Okay. Have you spoken to Mr. Flick?
Yes, those are the two gentlemen that I've spoken
Okay,
to.
okay. All right. We'll do those first, and then I have two sign-ins if you'll need time in between.
Thank you very much. Mr. Flick, come on up, please. Afterwards, see her.
All right. Good morning, Mr. Flick.
Good morning.
You're before the court this morning on two charges. Count 1 is disorderly conduct or breach of the peace. Count 2 is for resisting an officer or obstructing with violence. I find probable cause for these charges, and I will hear from the parties with recommendations as to count 2.
Your Honor, state would be requesting a $1,000 bond on count 2.
Judge, my understanding, speaking to Mr. Flick, I believe he has a relatively minor contact with the criminal justice system. He's 33 years old. Right now he's pursuing a business degree. He's studying at South New Hampshire College. He's doing their online program. Now he lives in Delray Beach with his kids. His kids are right now with his mother, the kid's grandmother. He's an Army veteran. He served our country from 2006 to 2012. He's basically paying for schooling through the GI Bill, and basically supports himself through disability. Judge, considering his lack of any significant priors, Judge, we're asking at this time if the court would consider straight ROR on Mr. Flick's behalf.
Mr. Linder, does he have any priors?
Showing out of Indiana, 2010, public intoxication. He was arrested in 2018 in Delray Beach for failing to appear in court. And that was stemming from a possession of marijuana case.
All right, I will grant the ROR on count 2. Mr. Flick, so that you understand, though you are going to be released today, that does not necessarily mean that's the end of this case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know about any future court dates you may need to be present for. Do you understand that?
I do, Your Honor.
All right, please make sure that you read that information Mr. Romero has just provided to you so that you know how to do that. All right, good luck to you.
And the next individual, Northcutt. Come
All
on
right,
up, sir.
Jeffrey
Who's approaching, Judge?
Northcutt. Thank you. All right, good morning, Mr. Northcutt.
Good morning.
You're before the court this morning on 3 charges. Count 1, distributing or delivering cannabis. Count 2, resisting an officer, obstructing without violence. 3 is for possession with intent to sell a controlled substance. I find probable cause, and I will hear from the parties at this time.
Judge, unfortunately, in speaking to Mr. Northcutt, from what he advised me, he's not going to be able to afford to post a monetary bond. He gets disability. He's 28 years old, been here his whole entire life. From what he advised me, basically he's looking forward to fighting these charges. But Judge, on this non-violent offense, we're asking if the court would consider releasing him on pretrial release.
Mr. Linder?
Looks like there's a history of mental health issues, Your Honor. He's been through mental health court. 2012, burglary of an occupied dwelling. 2011, felony possession of controlled substance.
Okay, so it seems that there's a possibility Mr. Northcutt could end up maybe being in Judge Porth's division at some point. Unfortunately, I'm not able to sign an order directly sending him to that division today, but that's definitely an issue that his attorneys can bring up. Based on that information, I'm going to leave the standard bonds in place for today's purposes. Good luck to you, Mr. Northcutt. All right, and then, Mr. Romero, if you want to go ahead and give me the other individuals, I'll pull them out, and when you're ready, I'll have them ready.
Yes, Judge. The gentleman is Douglas Sale on page 16.
Yes.
And then who was the other? And Mr. Garcia Arana, page what's he? 11? Garcia Arana. And Mr. Garcia Arana on page 11, Judge.
Okay.
Oh, and wait, one more. Garcia Arana
Yeah.
is going to require Spanish interpreter.
Okay.
Is that it? One moment, Judge. I think we're trying to make sure.
No problem.
Oh, they brought him?
Yeah, that's the one you talked to.
A judge, and then there's going to be a gentleman by the name of Robert Ladestier. He is on page 10 of the docket.
Okay.
Thank you, Judge.
All right, so you need time to speak to all 3 of them, right? Okay, all right. So while I'm waiting on those, I'll go to our sign-ins. I have 2 individual sign-ins, and then I'll go to Mr. Shade's cases after that. So my next on my list is on page 10, Babak Edapur. His wife and mother are in the courtroom. Thank you. All right, good morning, Mr. Edapur.
Good morning, Your Honor.
All right, Mr. Edapur, you're before the court this morning on 1 charge of touch or strike battery, domestic violence. I find probable cause. And Mr. Linder, I'll hear from the state first.
The victim is present and does want to address the court. He doesn't have any priors, so the state will be requesting a $500 bond.
$500?
Oh, and Jessica Etienne on behalf of the state.
Thank you, Ms. Etienne. All right, who's present on Mr. Edapur's hearing? Ladies, is there someone present on this hearing?
It's the victim, Christy Jones.
All right, Ms. Jones, are you just here to observe or to speak this morning? You don't have to, I'm just asking. Okay. All right, so I'm gonna tell you a few things that I say to everyone who comes to first appearances, okay? Number one, as a reminder, everything that we say today is being recorded and can be used against you and potentially him at a later date. Do you understand that? Okay, I say that to you because we're gonna find out shortly, I'm sure, what your role is, you know, as far as Mr. Edipore goes and everything, but you're here without an attorney. I don't know if you've already spoken to law enforcement or not, but I just need you to understand what we just said, all right? Number two, what I say to everyone is, since this is just the first appearance hearing, I'm not here to address the facts of the case or the background. I'm only addressing bond and release conditions today. Do you understand that?
I'll take a seat
I'm sorry?
then. I will sit then.
Okay, that's absolutely fine. Okay, go ahead and have a seat. All right, is Mr. Romero representing Mr. Edipore for this hearing? Okay.
Edipore, E-T-A-P-O-R.
Edipore.
Okay, he's on page 10. He's on page 10.
Oh, I'm ready to proceed. Sorry about that. I didn't
Okay.
hear what was going on.
That's okay.
I
That's
thought you
okay.
said you were gonna call other people that were signed in.
Yeah, he has his wife and mother are signed in.
Sorry, I apologize.
That's okay. So, Mr. Romero, the state is telling me that he has no priors and they're requesting a $500 bond.
Judge, no objection to a $500 bond.
Okay, all right. So, Mr. Edipore, I'm going to set the monetary bond at $500. Since this is a case involving domestic violence allegations, I'm going to impose an order of no victim contact so that you understand what that means until further order of the court with respect to the alleged victim in this case. That means no being in the same place at the same time, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, Your Honor.
All right, thank you very much. Good luck to you. Okay. And then I've also got on page 11, Roberto Sanchez. His wife is present in the courtroom.
I'm ready to proceed on Mr. Sanchez. Come on up, Mr. Sanchez.
And then I'm gonna do Mr. Shate's cases after this, so that'll give you some time. All right, good morning, Mr. Sanchez. You're before the court this morning on 2 charges. Count 1, aggravated assault with a deadly weapon, dating violence. Count 2, touch or strike battery, dating violence. I find probable cause, and who is here on this hearing this morning?
Your Honor,
What, well, I just wanted to see if, ma'am, I'm not sure who's here on this hearing this morning. Who's here on this one? Okay, are you here to observe or to speak this morning, ma'am? Just to observe, okay, that's fine. All right, go ahead, Mr. Linder.
Your Honor, I'm requesting a $5,000 bond on count 1 and a $1,500 bond on count 2. I don't see any history. This is based on the level of violence alleged in the affidavit.
Okay. All right, Mr. Romero, we'll go to you.
Judge, if I heard correctly, the state is asking for 2,000 on 1, 1,500 on 2?
5,000 on 1 and 1,500 on 2.
One moment, Judge.
Okay.
Judge, we're gonna try. Judge, on count 2, 1,500 is fine. On count 1, I know the state is asking for 5,000. We're gonna be requesting about a $3,000 bond on Mr. Sanchez's behalf. He believes he can find, somebody has the resources if the court were to set about a $3,000 bond. I did advise him as far as the no contact, he will be abiding by that no contact order. He's employed, Judge. He only makes about $16 an hour. He's been living in our community for more than half of his life. My understanding, and I'm sure the state will let us know differently, I believe this is his first time being arrested. So based on that, that's why I'm requesting a $3,000 bond on count 1.
All right, the bond on count 1 will be set at $3,500, and the bond on count 2 will be set at $1,500. Mr. Sanchez, there's also going to be an order of no victim contact, which I believe Mr. Romero's already discussed with you, but so that you hear it from me, that means until further order of the court, no being in the same place at the same time as the alleged victim, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yeah. You understand, sir?
Yeah. Can I ask
One moment, Judge.
All right.
And Judge, we're gonna be requesting a phone order as well.
All right, that's fine. I'll sign the phone order. This is on Roberto Sanchez. He's on page 11. All right, thank you, Mr. Sanchez. Okay, now I'm gonna go to Mr. Shates, 2 cases.
And Judge, whenever
Yes.
the court's ready, I'm ready to proceed on the 2 individuals that we had on recall.
Okay, all right, I'm gonna do Shate and then I'll do those.
Yes, sir.
And the interpreter's here, Judge.
Okay, great. So let me do our 2 MOs. All right, first up will be Elizabeth Ela on page 1. Good morning.
Good morning.
All right.
Hi there.
Good morning, Miss Ela.
How are you?
Miss Ela, you're before the court this morning on a municipal ordinance violation for criminal mischief. I find probable cause, and your attorney, Mr. Shate, is with me in the courtroom. Mr. Shate, I will hear from you at this time.
It'd be a time served offer, Judge.
All right. Miss Ela, if you want to resolve this case today,
Yes, ma'am.
the city's offer to you would be an adjudication of guilt with time served. Do you understand that?
Yes.
Okay, and I
That's good
understand.
news.
Okay, and I understand that, based on what I'm seeing in the probable cause affidavit, it seems like, this involves a neighbor's residence, so there is going to be a no return order to that residence. Do you understand that?
Judge, I'm
To
sorry.
my house?
Judge, I misspoke.
Oh, to my
I
neighbor's house.
100% apologize.
Okay, what's the matter,
I'm
Mr.
thinking of
Shea?
the other matter, Judge, on page 13.
Okay,
This is, this for the city of Hollywood. They would not be offering her time served on this. However, I don't see any significant history on this,
okay.
Ella. And due to the fact that there is a victim.
Miss Ella, one moment, let me
And
hear
due
from
to the
Mr.
fact there is a victim, Judge, the city needs to get in contact with that
Yeah.
individual and find out more information.
Okay,
So
that's-
we'd just rather have they had said they'd rather want the bond stay where it's at or have her sent to the division. I apologize.
Okay, so since there's, so Miss Ella, what Mr. Shade's telling me is that because this is a case that involves an alleged victim, they're not going to extend the plea offer at this time. So I'm gonna leave the $25 bond in place, okay? And as I said, there is going to be a no return order to the neighbor's house or apartment. Do you understand?
Yes, ma'am.
Okay, all right, so you got the $25 bond. Good luck to you, ma'am.
How do I, take care of that without any money?
So you can either, do you have a wallet or something in property at the jail?
No, ma'am.
Okay, do you have a cell phone that's in property at the jail,
Yeah, but it probably is dead, I assume.
Okay.
I don't know.
Well, if you would like, I can sign an order that Mr. Shake can provide me so that you can have access to your phone and try to call somebody to post that for you.
Judge, if she's unable to post the $25 bond, are we able to put her on pretrial release? Or
Based on these allegations, I
Understood.
wouldn't be comfortable with that at this time. But I will sign the phone order if that's gonna be helpful.
okay.
Okay, all right, so Ms. Ella, I'm gonna sign a phone order so you can have access to the phone to try to call get a contact information to try to call somebody, okay?
Yes, sir. Yes, ma'am.
All right, good luck.
Thank you. I'm gonna go to treatment tomorrow.
Okay, thank you.
Thank you.
All right, next will be Sunny Freeland on page 13.
Judge, and I'm sorry, this is the matter I was speaking about before. This is a trespass at a hotel, to be a time served, no return back to that
Okay.
hotel.
All right, which facility is Mr. Freeland at? Okay,
Main
thank
judge,
you.
and there's also
All right,
TC.
good morning, Mr. Freeland.
Yes, ma'am. Good morning.
All right, Mr. Freeland, you're here this morning on 2 charges. They're both misdemeanor capiases. The first is a municipal ordinance violation for trespassing. The second is a charge for driving with a suspended license. So let me ask, I have the offer to resolve on count one. Mr. Linder, do you have an offer to resolve on count two if he wants to resolve it?
Withholding court costs.
All right, so Mr. Freeland, if you would like to resolve these two matters today, then there is an offer from the city on count one, which is the trespassing charge. That offer would be an adjudication of guilt with time served and a no return order to that location. Do you understand that?
Yes, ma'am.
Okay, additionally, on count two, which is the driving with a suspended license, the state's offer to you would be a withhold of adjudication plus court costs. Do you understand that?
Okay,
All right.
yes.
And, Mr. Freeland, do you wish to accept those offers today?
Yes.
All right, I'm gonna ask you a few questions before we're done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Freeland, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Freeland, what plea do you wish to enter, guilty or no contest? I'm sorry, can you repeat that?
No contest.
All right, thank you. I accept your plea and find that it is freely and voluntarily given. So once again, your sentence as to count one will be an adjudication with time served and a no return order. And on count two, it'll be a withhold of adjudication plus court costs. Good luck to you, Mr. Freeland.
Thank you.
Thank you, Mr. Shea. Right, and, Mr. Romero, let's go ahead and take your Spanish case that you requested to be called out, turn since our interpreters here.
Yes, Judge.
That'll
His name
be-
is Mr.
Arana Garcia, right?
Correct.
Okay.
Senor Arana Garcia.
All right, and for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Good morning, Your Honor. Solange Sands, S-A-E-N-Z.
Thank you, Ms. Sands.
You're welcome. Your Honor.
Good morning, Mr. Arana Garcia.
Buenos días, señora Arana García.
You're before the court this morning on 3 charges.
Ha comparecido hoy, tiene 3 acusaciones.
Count 1, domestic battery by strangulation.
El primer cargo es violencia doméstica que tiene que ver con estrangulación.
Counts 2 and 3 are misdemeanor capiases.
Los cargos 2 y 3 son orden de arresto por delitos de grado menor.
Those are related to charges for disorderly conduct and assault.
Esos cargos tienen que ver con desorden público y también con agresión.
I find probable cause,
Decido que existe motivo fundado.
and I will hear the parties' recommendations as to count 1 at this time.
Vamos a escuchar qué dicen las partes en lo que tiene que ver con el primer cargo.
Your Honor, I'm requesting a $7,500 bond on count 1 and no victim contact.
El Estado pide fianza de $7,500 para el primer cargo y que le quede prohibido contactar a la víctima.
This is based on the level of violence,
Tiene que ver con el nivel de violencia demostrado.
the age of the alleged victim,
También la edad de la supuesta víctima.
and as you can see, he has a pending case on charges 2 and 3.
Y ya vio usted que tiene cargos pendientes para el cargos 2 y 3.
In that case, it's alleged that he went to a friend of his wife's home.
Ese caso se alega que él fue a la casa de una amistad de la esposa
This was about about 3 in the morning.
Era alrededor de las 3 de la mañana.
He believed that she was there,
Pensaba que la señora estaba ahí
and he tried to force his way into the victim's home while her children were also present in the home.
intentó entrar sin permiso a esa casa. Estaba ahí la supuesta víctima y también los niños de esa supuesta víctima.
Nothing further.
Nada más del Estado.
Mr. Romero?
Judge, unfortunately, Mr. Arana right now financially he's indigent. He's not working at this time.
De parte de la defensa, en este momento el señor Arana es indigente, no trabaja.
$7,500 is something he's not going to be able to afford to post.
7,500 es algo que él no va a poder pagar.
Now, my understanding, Judge, I did advise him. The court will impose no contact. He will have no contact with the alleged victim.
Y ya le dejé saber que la corte va a pedir que le quede prohibido tener contacto con la supuesta víctima. Ya le avisé sobre eso.
Now, he does have a brother that resides here in Broward County that specifically he's going to be reaching out to. Hopefully, he can help post his monetary bond.
Él tiene un hermano que vive aquí en el condado de Broward y se va a comunicar con él para tratar de ver si le puede ayudar a pagar la fianza.
His financial resources are limited. I believe he installs tiles for a living.
Los recursos económicos del hermano también son limitados. Me parece que instala losa como trabajo.
So we're going to be requesting a $3,000 bond on count one and a photo order on Mr. Arana's behalf, Judge.
Entonces vamos a pedir que la fianza del primer cargo sea $3,000 y que también firme una orden dando permiso para tomar fotos del señor Arana.
I will sign the photo order.
Sí, voy a firmar la orden para que le tomen fotos.
The bond on count 1 will be set at $5,000.
La fianza del primer cargo va a quedar en $5,000.
I will leave the bonds in place on counts 2 and 3.
Las fianzas que están impuestas en 2 y 3 van a quedar en lugar.
I do see he's set for a status hearing with his division judge tomorrow morning.
Mañana por la mañana debe comparecer para una audiencia de evaluación de caso. Es con el juez que está asignado a su división.
Mr. Arana, there will also be an order of no victim contact.
Señora Rana, entonces ahora tiene una orden prohibiendo contacto.
That means with respect to the alleged victim in this case,
Y eso quiere decir, en lo que tiene que ver con la supuesta víctima de este caso,
you are not to be in the same place at the same time as this person.
a usted le queda prohibido estar en el mismo lugar al mismo tiempo que esté esta persona.
That includes no phone calls or text messages to this person.
También incluye que le queda prohibido poder llamar o enviarle mensajes por teléfono a esta persona.
And no third-party contact or social media contact with this person.
No puede enviar a terceros para comunicarse con ella, tampoco puede usar medios sociales para intentar comunicarse.
Do you understand that, sir?
¿Entendió, caballero?
¿Entiendes?
Yes.
All right. Thank you.
Gracias.
All right, do I have any other cases at Maine that require a Spanish interpreter?
No more here at Maine, Judge.
Okay, Mr. Miller, do you have any cases at any of the other jails that needs a Spanish interpreter? Okay, all right, Ms. Sands, thank you very much.
You're welcome. Thank you, Your Honor.
Have a great afternoon.
Thank you.
All right, so now, Mr. Romero, I'm ready to go to your other two cases. We'll start off with Douglas Sale on page 16.
He's approaching, Judge in Maine.
Thank you. Before I proceed, is count one supposed to be attempted, Mr. Linder?
Yes.
All right. Good morning, Mr. Sale.
Good morning, ma'am.
Mr. Sale, you're before the court this morning on 4 charges. Count 1 is attempted premeditated murder. Count 2, possession of weapon or ammunition by a convicted Florida felon. Count 3, criminal attempt to solicit or conspire in a capital felony. Count 4 is an out-of-state felony hold that has a no bond hold out of the state of Oklahoma. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, I'm seeking a finding of proof evident or presumption great on count 1 for attempted first-degree murder, requesting that Mr. Sale be held no bond on that count. I have no objection to an ROR on count 3. On count 2, I'm requesting a $25,000 bond based on the allegations of the use of the firearm in this case, and also considering that he's wanted out of Oklahoma for possession of a firearm by convicted felon.
All right. Mr. Miller, we'll start with your response.
Judge, I would argue count 3, once there's no conspiracy or
Attempt.
there's no conspiracy or attempt that it was a completed act, and therefore there is no probable cause to hold him on count 3. I would object to the court finding probable cause. Proof evident presumption great based solely on a probable cause affidavit. Beyond that, though, I would defer any additional argument to another day.
And Your Honor, the officer added count 3 because he's charging him with attempted murder.
I'm going to leave my probable cause finding in place for that, but count 3 will be an ROR. All right, as to count 1, I have reviewed the probable cause affidavit, including all the information provided in that document, which includes statements that were made by Mr. Sale to law enforcement, in addition to other statements made by other parties involved in this incident. At this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Sale be held no bond on count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter. So at this time, I will hear from Mr. Romero with his recommendation on count 2.
Judge, based on the fact that the court found proof evident presumption great count 1, holding him no bond, and he has an out-of-state hold, nothing to add from the defense except for a photo order request.
Okay,
In addition to a photo order, I've been asked to have the psych eval for this gentleman.
that's fine. I will sign those orders. All right, and Mr. Linder, the state's recommendation on count 2 is $25,000, is that correct?
Yes, Judge.
All right, so in light of the circumstances, I'll set a $25,000 bond on count 2. And as I said before, count 3 will be an ROR. The no bond holds will remain on counts 1 and 4. All right, thank you. Okay, so next will be Robert Leducier.
Judge, he advised me he has private counsel Colette Drimmer. So I don't know if my colleague already reached out to her.
And Judge, I spoke to Ms. Drimmer this morning.
Yes.
She has not been retained on this matter, and she advised that her client should feel free to let the public defender assist him this morning.
All right.
Whatever.
Judge, I believe Mr. Ludicer just advised me, I believe he just said that he understands he doesn't have Ms. Drimmer, and I think you said you don't want the public defender.
Yeah, I don't need either lawyer, Your Honor.
All
I
right.
believe you'll be able to make the decision for me, Your Honor.
Okay, so Mr. Leducier, let me just ask you a couple questions just to make sure I have it on the record. Do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am. Yes, ma'am, I do.
All right, and are you declining the services of the public defender at this time?
Yes, ma'am.
Okay, all right. Mr. Leducier, for the record, you're before the court this morning on one charge of violating an injunction for being within 500 feet of a residence. I find probable cause, and I'll go to Mr. Linder first to hear the state's recommendation. Excuse
May I
me.
ask you a question?
Mr. Leducier, give me one moment, okay? Let me hear from the state, and then I'll go to you, all right? Okay, just one moment. Ms. Etienne, go ahead.
Yes, the state will be requesting a $1,000 bond on this case.
I'm sorry, I can't hear you, Ms.
The
Etienne.
state will be requesting a $1,000 bond on this case. He has a current pending charge against the same victim as to why he got the violation of injunction on this case.
All right, pretrial is standing up, so I'll hear from pretrial.
Nancy Mapson, pretrial services. He's currently out on pretrial for battery case number 20001-632 MM10A. He was placed on pretrial February 20th of this year. We're requesting that his pretrial is revoked in that case, Your Honor.
Ms. Etienne, before I make a decision on this pretrial request, can you just verify for me the battery case that's on pretrial? Is that involving the same alleged victim? Is that in the present case?
Yes.
All right, Mr. Ledouceur, I'm gonna go to you for a moment. You said that you had a question for me, so I'm just gonna have the deputy turn the speaker on. Before you say anything, though, I'm just going to say, for the record, remember, everything that we say is being recorded and can be used against you at a later date, so I would suggest that you don't say anything about the underlying facts or background of the case. Do you understand that?
Sure.
Okay.
Now,
What was your question?
the no contact order was lifted last Thursday.
Okay.
But Judge McHugh lifted the no contact order last Thursday by request of Jennifer Turner.
All right, so I'm gonna.
And the reason I had called Broward County Sheriffs is because Broward County is failing.
Okay, all right, hang on. One at a time. Hold on. Let me just have the state verify that information you just gave me about Judge McHugh. Just give me a moment so they can tell me what's going on with that.
Your Honor, what was done was that they could have contact via text, phone, or email. No physical contact. He still wasn't allowed at the home. It's only third-party contact as far as for the child.
Okay, all right.
And Your Honor, there was only third-party contact. Every time I went to the house, I called Broward County Sheriff's 15 minutes prior to meet me at the house. I never had contact with Jennifer Turner. I've never even texted. I mean, this Jennifer Turner is a psychopath
Okay,
and a perjurer.
all right, Mr. Ledouceur.
She's a
Mr. Ledouceur, just a moment, okay? Remember, today is just the first appearance hearing, so any of this other information you're giving me is for you to speak to Ms. Drimmer, your attorney in the other case about
I
after
don't need
today.
Drimmer anymore, Your Honor.
Okay, that's fine. I just need you to understand that's for you to address after today's hearing, okay? All right. So, based on the order by Judge McHugh, obviously that includes the no physical contact. You've already told me that. Is there a no contact with regard to the residence location?
Correct. As far as for the child, it's supposed to be a third-party contact. It's not him dropping the child off at the house and him picking up the child from the house. It's supposed to be a third party, not him.
Okay.
Broward County Sheriff's was the third party. Jennifer Turner refused to give me my son, which is why I called Broward County Sheriff's to get them involved. My son is living in danger because of Broward County for 4 months.
Mr. Ledouceur, please, okay? I'm just talking about, this is just for the first appearance hearing. Any of this other information.
There's a lot more in here, ma'am. There's a baby in the hands of death because of Broward County.
Okay, but listen to me, please. Today is just your first appearance hearing, so any of this other information that you're giving me is for you to address after today, okay? So just give me a moment, please. All right. All right, as to the case that was on pretrial, I am going to grant pretrial's request to revoke the pretrial status in that case, which for the record, again, is case number 20001632MM10A.
Looks like I live here.
Ms. Etienne, I heard your recommendation, Esteban, in the present case. Do you have a recommendation in the case that was on pretrial? I'm sorry?
He would ask that the bond be, that he be held no bond.
All right.
Don't need one.
Okay. All right. In the case that was on pretrial, I will place a no bond hold so that Mr. Ledouceur can see his division judge to address that matter. And I will place the $1,000 bond on the case that is before me today. All right. Good luck, sir.
Yeah, am I allowed to say anything here?
I would advise you just to tell your division judge after today.
Well, I got something else to say, Your Honor.
Okay, Mr. Ledouceur, I've already addressed everything we're going to address for this morning. All right. Good luck. Yes. That's already in place, but that's fine. All right. Thank you. Are there any other cases that need to be called out of turn from any of the jails? All right, so I'm going to start down our regular list. Next up will be Stephanie Nelson. Stephanie Nelson. All right.
She's here, present, Judge Amain.
Thank you. Good morning, Ms. Nelson.
Good morning.
Ms. Nelson, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, she does have a prior charge of battery where no action was taken against the same victim, and that was in 2019, and she has a 2012 municipal ordinance excessive barking adjudicated guilty.
What's the state's recommendation?
The state will be requesting a $1,000 bond.
All right, Mr. Romero.
Judge, that's reasonable under the circumstances.
Okay, so I'm going to set the bond at $1,000. There will be an order of no victim contact. Ms. Nelson, so that you understand that order, it means no being in the same place at the same time as the alleged victim, no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you very much. Yeah. Latanya Holloway.
She's here, Main Judge, approaching. Come on
Thank
up,
you.
ma'am.
All right, good morning, Ms. Holloway.
Good morning.
Ms. Holloway, you're before the court this morning on one charge of touch or strike battery, dating violence. I find probable cause, and I'll hear from the parties.
Your Honor, I'm not showing any priors. However, based on the facts of the case, the state will be requesting a $1,000 bond.
Judge, no objection. At this time, I'm going to be asking for a photo order so we can photograph Ms. Holloway's injuries. And number two, a property order so that she could go back one time with law enforcement to retrieve her property.
All right, I will sign the photo order and the property order that were requested in Ms. Holloway's case. I will set the bond at $1,000, and there will be an order of no victim contact. Ms. Holloway, so that you understand that order, it means no being in the same place at the same time as the alleged victim. That also includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, ma'am?
Yes.
All right, thank you. He said photo and property. Mhm. All right, I have a sign-in, if you have him present at the jail, that's on page 17. Altravon Bernard Cromwell, he has family present in the courtroom.
Judge, he is here. I'm going to need a moment to speak to him.
Okay, that's fine, just let me know when he's ready. I'll keep going.
Thank you.
All right, next up will be Tanisha Pitts.
North Broward, I believe, Judge?
Okay, let me go to North Broward. All right, yes, Deputy, I'm sorry.
She refused to attend.
Okay, this has been reset this was reset throughout the weekend. It says medical reset on here, but were they refusals or medical resets? Does anybody know?
Refusals.
Okay. Mr. Miller, is your office representing Ms. Pitts on this case or any case? It's Tanisha. Last name is Pitts, Pitts. Okay. All right, how about I appoint you to represent her on this case? Thank you. And I believe that probable cause was already found in this case. So, Mr. Miller, are you going to waive her appearance for today's hearing? This is whoever's next at North Broward. Okay. All right. Ms. Etienne?
No, Your Honor. Well, based on her priors and it being against the same victim. The state would be requesting a $5,000 bond.
What are the priors?
She has as he stated, a current felony battery with prior conviction. She has a 2019 battery against the same victim in the felony case. She has a 2017 battery, which was declined to adjudicate, which is the same victim in this case, Dexter Kelly. She has a 2017 battery where prosecution was dropped with the same victim in this case. She has a 2015 battery, which was dropped as well against the same victim in this case.
All right, that's fine. I've heard enough. I'm gonna set the bond at $5,000, and I'll put an order of no victim contact on here, which she can address with her division judge after today. All right, thank you very much to both of you. All right, the next on my list is Heidi Landers. All right, thank you. Good morning, Ms. Landers.
Good morning.
Ms. Landers, you're before the court this morning on one charge of aggravated battery causing bodily harm or disability. I find probable cause, and your attorney, Mr. Miller, is with me in the courtroom, and at this time I will hear recommendations from the parties.
Ma'am, can I say something?
Ms. Landers, this is just a time for you to listen, okay? I'm gonna hear from the attorneys first.
Your Honor, the state would be requesting a $10,000 bond, no victim contact. First, just looking at the booking sheet, numerous aliases have been used in the past. Ms. Landers has been qualified as a habitual offender and a PRR offender, and it's on a violent matter. In 2001, she was convicted of aggravated battery, great bodily harm, sentenced to 15 years and a day in state prison as a habitual offender and PRR offender. Her most recent arrest was last week. She was arrested on March 2nd in Osceola County on an out-of-county warrant out of Polk County on a felony matter, and posted that bond. There is a significant history, including priors that have resulted in prison sentences for strong arm robbery, burglary, sale or delivery of cocaine, sale or delivery of cocaine or heroin within 1,000 feet of a school, possession of cocaine, and nothing further, Judge.
Mr. Miller, we'll go to you.
Yes, thank you, Your Honor. Ms. Landers is a lifetime resident of South Florida. She's been living at her current address for the past 4 years. She works as a house cleaner. She's currently unemployed and receiving SSI. She does have a place to stay that is separate and apart from the alleged victim. We're asking the bond be set at $1,000, Judge.
Your Honor, can I please say something?
Please don't.
Ms. Landers, Mr. Miller, who's acting as your attorney today, is advising you not to speak today. I'm only addressing bond and release conditions today, so if there's okay, hold on.
Okay.
So
yes.
if there's anything that you want to say about the case, I need you to understand that I'm not addressing anything to do with the facts of this case or the background. That's not for today. Do you understand that?
Yes, ma'am.
Your Honor,
Yes, ma'am.
if the court wants to put this on recall, I'll be happy to speak with her sidebar.
All right. Ms. Landers, would you like to have a moment to speak with Mr. Miller, your attorney, privately on the telephone before I hear from you?
Who is my attorney?
Mr. Miller is acting as your attorney today. He's in the courtroom with me, and if you have a question, then he can speak with you privately on the phone if you would like to take a moment to do that.
Yes, please.
Okay, all right. I'm going to put this case on a brief recall, and Mr. Miller's going to call you on the phone there at the jail. Once you've spoken to him, I'll bring you back up, okay?
All right, thank you so
All right,
much.
you're welcome. Just let me know when you're ready, Mr. Miller. All right, so let's go to Mercedes Brown. Is she at Maine?
Ms. Brown is here at Main, Judge.
Okay. All right, good morning, Ms. Brown.
Good morning.
Ms. Brown, you're before the court this morning on a misdemeanor capias.
Judge.
Yes.
She declined the service of public defender. I just looked at my notes.
Okay, that's all right. Ms. Brown, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes.
And are you declining the services of the public defender at this time?
Yes.
All right, so for the record, you're before the court on a misdemeanor capias. This is related to a charge for petty theft. And let me first ask before I inquire, Mr. Linder, is there an offer in this case, or does this involve restitution?
There's an offer. The offer is withhold court costs, no return to the Walmart at 5571 State Road 810 in Coconut Creek.
All right, Ms. Brown, are you interested in resolving this case today?
Yes.
Okay, so what Mr. Linder has told me is that the state's offer to you would be a withhold of adjudication plus court costs and a no return order to that Walmart that was referenced. Do you understand that?
Yes.
All right, I want to advise you that since this is a charge for petty theft, if you get arrested for petty theft 3 or more times, then the state can file that as a felony, which would subject you to a potential prison sentence. Do you understand that?
Yes.
All right. So, Ms. Brown, before we are done today, since you want to accept that offer, I'm going to ask you a few questions, okay?
Okay.
All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Ms. Brown, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with an attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I understand.
All right. And Ms. Brown, what plea do you wish to enter? Guilty or no contest?
Okay, wait. One thing.
Okay.
No contest is.
I'll explain the difference to you, okay? So you have the option of entering a plea of either guilty or no contest. Whichever you choose to plea, it doesn't change the plea offer that has been extended to you. This is a matter for the record. If you enter a plea of guilty, then you are simply admitting to your guilt on the record. If you enter a plea of no contest, you are not admitting to your guilt, but you are not contesting or challenging these charges so that you can accept the plea offer. Do you understand?
Okay, yes, I do understand that.
All right, so how would you like to plead? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Once again, your sentence will be a withhold of adjudication plus court costs, and there will be the no return order that we discussed. And you understand that?
Yes, ma'am, I do.
All right, thank you very much, Ms. Brown. Good luck to you.
Thank you.
Mr. Miller, are you ready for me to go back to North Broward?
I am, yeah,
All right,
Your Honor.
let's go back to North Broward for Ms. Landers. Okay, Mr. Miller, anything you want to tell me on Ms. Landers' case that's different from what we've already discussed?
Judge, we're going to ask the court, instead of $1,000 bond, if the court would consider pretrial release, she can handle house arrest. She lives at her own place, so it's, she's separate and apart from the alleged victim.
Mr. Linder, you want to be heard?
She was sentenced to 15 years for an aggravated battery against someone else. There's a witness that corroborates the victim's version of events that she was hitting the victim with a tire iron.
All right. Based on the circumstances, I'm not willing to grant pretrial release at this time. I'm going to set the bond at $7,500, and there will be an order of no victim contact. If there needs to be a bond modification, then Ms. Landers can have her attorneys address it with the division judge. Ms. Landers, so that you understand the no victim contact order, that means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that, ma'am?
Yes, ma'am. I do understand that, ma'am, but the
All right.
charge, the last charge I had, ma'am, that was like 15 years ago.
All
I
right.
was on drugs
Miss
then.
Landers, Miss Landers,
I mean, the
Miss
state is
Landers,
just really
Miss
doing too
Landers,
much. Yes,
please,
yes.
please. Thank you. I want you to address it with your attorneys, and they'll handle it with the division judge. All right, good luck to you, ma'am. Next will be Nikita Levels.
She's here at Main, Judge, approaching.
Thank you. All right, good morning, Ms. Levels. You're before the court this morning on 6 charges. Count 1, resisting an officer, obstructing without violence. 2 is a felony probation violation with a no bond hold. 3, possession of cannabis, 20 grams or less. 4, introducing contraband into a detention facility. 5, tampering with or fabricating physical evidence. And 6 is a felony probation violation which has a no bond hold. I do see Ms. Levels is set to go before her division judge tomorrow morning to address the probation violations. I find probable cause, and do the parties wish to be heard on the other counts?
Judge, based on her no bond hold, not at this time, Judge.
Okay, all right. Thank you. Good luck, Ms. Levels. Mr. Romero, are you ready on Cromwell yet?
Oh, yes, Judge, I am.
Okay, let's go ahead and go to Mr. Cromwell's case.
Mr. Cromwell? He's approaching, Judge, here at Main.
Thank you. Okay, which family members are here in this case? Are you here to observe or to speak this morning? Are you here just to see what happens, or are you here to speak? Okay, that's fine. All right, good morning, Mr. Cromwell.
Good morning.
You're before the court this morning on 3 charges. Count 1, aggravated assault on an officer. Count 2, fleeing with disregard of safety to persons or property. Count 3, reckless driving, first offense. I find probable cause for these charges, and I will hear from the parties their recommendations at this time.
Your Honor, the state is requesting a $20,000 bond on count 1, a $5,000 bond on count 2, pretrial release with a GPS monitor. I'm concerned, based on the allegations, that Mr. Crowell intentionally drove at the direction of a law enforcement officer, trying to strike the officer. In the sworn affidavit, Officer Hoffman mentions that if Officer Thomas did not get out of the path of Mr. Crowell's vehicle, he would have likely been struck and seriously injured or killed. Ultimately, the vehicle that Mr. Crowell was driving was struck another vehicle, almost struck numerous pedestrians, and they had to jump out of the way of his vehicle. And all of this was done, Your Honor, while Mr. Crowell was out on bond for carrying concealed firearm.
Judge, I understand this, the facts and the allegations are serious. However, in speaking to Mr. Crowell, he is disputing these allegations. He is looking forward to fighting this case and having his day in court, particularly on count 1, Judge. Judge, my understanding as the state did say he is out on a case. My understanding he's been going to court. He's been at least 5 times. His next court date, April 3rd. He is out on bond on those cases. Now he's 21 years old, been here his whole entire life. He is working. He works for UPS. He's been there for about 2 years and makes on an average about $15 an hour. He lives with his grandparents. Judge, my understanding is he's going to be reaching out to his family to help post his monetary bond. That's why he advised me that he doesn't think that his family can come up with what the state initially asked for as far as $25,000. That is why on count 1, we're going to be asking for a $10,000 bond. And on count 2, we're going to be requesting a $2,500 bond on Mr. Crowell's behalf.
All right. Sir, are you a family member?
Yes, I was there during this.
Okay, so Are you looking to speak this morning?
Yes.
Okay, so I'm gonna tell you what I say to everyone who comes in for first appearances. Number one, everything that we say today is being recorded and can be used against you and potentially him at a later date. Do you understand that? All right, number two, since today is just the first appearance hearing, I'm not addressing anything about the facts of the case or the background. So if you were a witness, I don't want you to tell me anything about what may or may not have happened. That's something for you to discuss with the attorneys, all right? So today I'm only addressing bond and release conditions. Do you understand that?
See.
Okay, that's all right. That's fine. You can have a seat if you want. That's fine. Okay. All right, Mr. Linder, besides the case that he's out on bond for, are there any other priors?
I'll have to check his history.
Okay. Ma'am, are you looking to speak today?
Yes.
Okay, I'm just gonna say to everyone in the courtroom, if you wanna speak on a hearing, please let me know right away. Don't wait until I'm going down the way and then we're all deciding as we go along that we wanna speak, because we gotta keep things moving in here. So, ma'am, you've heard what I've already said about the only things I'm addressing today. Bond and release conditions, that's it. You understand that? All right, if you wanna speak, then I will place you under oath and then I'll let you tell me what you wanna say, okay? All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
And will you please state your name and spell your last name? You can go ahead and put your hand down.
It's Audrey Kelly, Kelly.
All right, and Ms. Kelly, I'm just gonna ask you to speak loudly into that microphone in front of you so that they can hear you over at the jail, okay?
Okay, I was just wondering, can you like lower the bonds?
Well, right now I'm about to decide on what the bond is going to be. So I hear recommendations from the attorneys. I take into consideration anything as far as other pending cases, prior history, what the allegations are, and then I make a decision on that. So right now I've heard the recommendations that they both made to me. I'm waiting to hear on if there's any other prior history that hasn't been presented, and then I'll make a decision on that. Okay?
Okay.
All right, is there anything else you want to say?
No, that's it.
Okay, all right, you can go ahead and have a seat, Ms. Kelly.
Your Honor, the only other thing I see is an arrest in 2018 for battery that was dropped. I would also bring to the court's attention in his pending carry and concealed firearm case, he's allegedly was found in possession of a Glock 19 with an extended 30-round magazine. The firearm was loaded with 21 live rounds of 9mm ammunition.
All right. I am not going to take any action in the pending case as far as revoking any bond or anything, but Mr. Romero, you can advise Mr. Crowell when he's out on bond, that is a potential effect that can happen. All right, the bond on count 1 is going to be set at $15,000. The bond on count 2 will be set at $2,500. If Mr. Crowell does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. All right. Mr. Crowell, good luck to you, sir. Thank you. All right. Thank you, guys. Okay. Our next case will be Pamela Curse.
She's approaching. Judge, here at me. Come on up, man.
Thank you. All right, good morning, Ms. Curse.
Good morning.
Ms. Kirsch, you're before the court this morning on 3 charges. Count 1 is attempted murder, premeditated. Count 2, criminal attempt to solicit or conspire. Count 3 is fleeing with disregard of safety to persons or property. I find probable cause for these charges, and I will hear from the parties, starting with the state at this time.
Your Honor, the state would be seeking a finding of proof evident or presumption grade on count 1 for attempted murder. Ask that Ms. Kirsch be held no bond. On count 2, I'm fine with an ROR. count 3, $25,000 bond based on the allegations contained in the affidavit.
Mr. Miller, we'll begin with you.
Judge, I'll just renew the same argument of her co-defendant. Would object to the court finding probable cause based solely on a the court finding proof evident presumption great based solely on a probable cause affidavit. Beyond that, we will reserve argument for a future date.
All right, as I did say in the co-arrestee's case, I have reviewed the probable cause affidavit and all of the information contained therein, including statements that were provided by each of the defendants as well as other individuals that were involved with respect to these allegations. At this time, the court is going to make a finding of proof evident presumption great in order that Ms. Kearse be held no bond on count 1. That will be without prejudice for her to have the appropriate Arthur hearing before her division judge in order to further address that matter if necessary. Mr. Romero, do you wish to be heard on count 3?
Considering the court ruled proof evident presumption great is holding her no bond on count 1, we defer any arguments to be heard in front of her division judge.
Okay. All right, so count 1 is going to have the no bond hold. Count 2 will be an ROR, and count 3, bond will be set at $25,000. Thank you. Next will be Ashley Johnson.
Broward, Your Honor.
Thank you. All right, good morning, Ms. Johnson. Ms. Johnson, you're before the court this morning on 8 charges. Count 1 is attempted premeditated murder. Count 2, possession of weapon or ammo by a convicted Florida felon. Count 3, criminal attempt to solicit or conspire in a capital felony. Counts 4, 5, 6, and 7 are felony capiouses, which have no bond holds and are not for magistrate. Count 8 is an out-of-county felony hold that has a no bond hold on it. I find probable cause for these charges, and I will hear from the parties beginning with the state at this time.
Your Honor, on count 1, the state would be seeking a finding of proof evident or presumption great for attempted murder. Ask that Ms. Johnson be held no bond on that count. On count 2, again, a $25,000 bond considering the allegations and the fact that she has a warrant out of another state based on a firearm offense. Not seeking any type of bond to be set on count 3.
Mr. Miller?
Again, Judge, I would object to the court finding proof evident presumption great based solely on a probable cause affidavit. That being said, we will reserve any further argument for another date.
Okay. As I have said in each of Ms. Johnson's co-arrestees cases, I have reviewed the probable cause affidavit regarding these allegations, and based on that information, at this time, the court is going to make a preliminary finding of proof evident presumption great and order that Ms. Johnson be held no bond on count 1. That will be without prejudice for her to have the appropriate Arthur hearing before her division judge. With respect to count 2, bond will be set at $25,000. Count 3 will be an ROR. And Ms. Johnson, I do see that you're going to have a status hearing with your division judge tomorrow morning to address the capious matter.
What does that mean, ma'am?
It
The
means-
capious, are those the warrants that I had in Broward before I came down here?
That's correct. That's
Okay,
correct.
thank you, ma'am.
All right, thank you. Okay.
And Judge, I've requested a photo order for Ms. Johnson.
That's fine, I'm signing that order. All right, next will be Jennifer Flores.
No problem.
Thank you. Good morning, Ms. Flores.
Good morning, Your Honor.
Ms. Flores, you're before the court this morning on 3 charges. Count 1, second-degree petty theft. Count 2 is a felony probation violation, which has a no bond hold. That is out of Miami-Dade. And count 3 is a felony out-of-county hold with the no bond hold that is out of Miami-Dade. I find probable cause. Mr. Miller, do you wish to be heard?
Your Honor, I spoke with Ms. Flores this morning. She's got the no bond holds from Miami-Dade. I explained to her that even if the court were to grant her a release on recognizance, that would not get her to Miami-Dade. It's going to take a court there ordering her back before she can be brought back. And I've further advised her not to resolve these cases because in addition to whatever else she is facing, this would be an admission to a new violation of probation.
Correct.
And so there's really not a whole lot that we can do here today or ask the court for.
Okay. All right. Does the state wish to be heard on anything?
Judge.
All right. So, Ms. Flores, in light of the no bond holds that you have out of Miami-Dade, I'm going to leave the $25 bond in place on count 1. Good luck to you, ma'am.
Your Honor,
Yes.
can I speak?
Well, Ms. Flores, I don't want you to say anything about the facts of the case, okay? You understand everything that Mr. Miller's discussed with you this morning?
Yes, Your Honor, but I was just wanted to speak to my family. I haven't been able to talk to nobody, and I'm 6 months pregnant. That's why I wanted to resolve the case, just so I could get sent back to Miami. That's what I'm on probation for.
Okay, but you understand what Mr. Miller said. Even if you resolve the other case, you're not going back to Miami right now. So based on his conversation with you, I'm going to leave the bond in place. If you need to get in touch with someone on the phone, then you can certainly call whoever you need to call in order to do that. Is there something preventing you from calling them?
Yeah, they didn't let me call intake because they said I was pregnant, and my mom she just don't know how to put money on the phone. So I would like to please ask you, is there any way I could call her just to let her know what's going on?
Judge, she clearly knows the number. If they're not letting her call, that's not anything that the court can do. I mean,
Okay, well, let me just have, can I have one of the deputies at North Broward just come for a moment? Hi, deputy.
Good morning.
Deputy, good morning. Is there I don't know what the protocol is at North Broward, so I'm just gonna ask you as far as phone calls go. Do they have access to phones there, or is there anything preventing that matter?
Yes, I've spoken with Ms. Flores and I've advised her what to do and how to go about making a phone call.
Okay. So, Ms. Flores, you need to follow whatever the protocol and procedures are that they have in place there at the jail, all right?
Okay, Your Honor.
All right, good luck to you, ma'am. All right, next will be Teresa Crane. She's, okay. She on loan? All right. And I know probable cause was already found in her case. We're just waiting on bond. All right, Martavius Davis. Thank you.
He's approaching Judge. You got me?
Thank you. All right, good morning, Mr. Davis. Mr. Davis, you're before the court this morning on an out-of-state felony hold, which has a no bond hold out of the state of Georgia. I find probable cause. And Mr. Davis, since this is an out-of-state hold, that means you're going to go before the extradition judge. That will probably be tomorrow or Thursday to address how that matter is going to be handled. All right, good luck to you, sir. Ralph Young.
Mr. Young, come on up, please. He's approaching Judge.
Thank you. Good morning, Mr. Young.
Good morning, Your Honor.
Mr. Young, you're before the court this morning on one charge of aggravated battery causing bodily harm or disability, domestic violence. I find probable cause, and I'll hear from the parties.
Your Honor, state would be seeking a $10,000 bond based on the level of violence that caused the victim to lose a tooth, and his criminal history, which includes 2008 trafficking cocaine, conspiracy to traffic cocaine over 400 grams. He was sentenced to 7 years in state prison, released in 2014. Possession of cocaine, 05, 2-year state prison. Delivery of cocaine, 01, cruelty to animals, 99. There are additional priors, but I will not go into those specifically, Judge.
Mr. Romero, we'll go to you.
Judge, unfortunately, Mr. Young's not in a position to post that sort of monetary bond, which the state has recommended. Now, he's been residing in South Florida now from what he advised me about 3 months. He's 44 years old. He's working at this time. He got a construction job. He's been there for about 2 months employed, making approximately $10 an hour. Now, he'll be living separate and apart from the alleged victim. He has family that lives in Broward County that he's gonna hopefully lean on so they can help him through this ordeal. My understanding, though, the family member is a limited financial resource, specifically his sister is not working, she receives disability. He believes that most she can afford is if the court were to set $1,000 bond. That's why we're requesting $1,000 bond on Mr. Young's behalf.
Your speaker's on, Mr. Romero. All right, the bond's gonna be set at $7,500. There will be an order of no victim contact. Mr. Young, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that, sir?
Yes, ma'am.
Thank you very much. Next will be Corey Ann Moore.
Mr. Moore, come on up, please.
Good morning, Mr. Moore.
Good morning.
Mr. Moore, you're before the court this morning on 2 charges. Count 1, aggravated assault with a deadly weapon, domestic violence. Count 2, touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $10,000 bond on count 1, a $5,000 bond on count 2, considering the allegations that support the misdemeanor battery. Pretrial release of the GPS monitor, no victim contact. I see no history, but I have concerns based on the alleged threat to kill. Also noting it would appear that the couple's child was present in the home when this occurred, at a minimum, if not witnessed by the child.
All right, Mr. Romero.
Judge, as you heard, Mr. Moore has no prior contact with the criminal justice system. He's 22 years old, been living here his whole entire life. Now, he lives separate and apart from the alleged victim. He resides in Pompano Beach. He's been renting at the same apartment for 1 year. His monthly rent is approximately $948 a month. Now, he's been working for the same company for 2 years called Capstone Logistics. He's a loader. He loads things. He makes approximately $12.50 an hour. He does have family here that live in our community. He's relying on his sister to help post his monetary bond. We're going to be requesting a $3,000 bond on count 1 and a $1,000 bond on count 2, so a total bond request of $4,000 on Mr. Moore's behalf, Judge.
Bond on count 1 is going to be set at $5,000. The bond on count 2 will be set at $2,500. I'm not going to impose the GPS requirement at this time. However, there are going to be orders of no victim contact and an order that Mr. Moore possess no weapons, firearms, or ammunition. Mr. Moore, with respect to the no victim contact order, that means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, additionally, with respect to the order that you possess no weapons, firearms, or ammunition, that means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, ma'am.
All right, thank you. Next will be Jairo Sanchez. Okay. Yes, all right. Then next will be Orlando Henry. All right. All right, I'm being told, Mr. Henry, that your bond has been posted. Oh, hold on one second. Hold on one second. Hold on. Pretrial is telling me he's on pretrial for something. Go ahead.
He's currently out on pretrial for case number 1800754 CF10A for felony petty theft. He was currently placed on pretrial June 25th of 2018. Again, the case number is 1800754 CF10A. Felony petty theft. Requesting pretrial is revoked.
Yes, Mr. Miller.
Considering the courtroom that this is in, and he does have a conditional release review set for May 1st. I would ask the court, in this case, based on the nature of these charges, not to take any action on pretrial's request and to allow Mr. Henry to address these matters in front of Judge Porth.
We're gonna go sidebar for just a moment so they can give me some more information. Go off the
No
record
problem,
just a
Joe.
moment. So after discussing Mr. Henry's two cases, he has, I'm just going to restate for the record, he's currently on pretrial in case number 1800754 CF10A on a charge for felony petty theft that is currently pending in front of Judge Porth. Because of the nature of the charges in each case, I am going to grant pretrial's request to revoke Mr. Henry's bond in that case, and I'm going to order that he be held no bond so that Judge Porth can address that matter and decide how he wants to handle it, whether there's any modifications that need to be made. In Mr. Henry's present case, I'm not going to take any action, obviously, with respect to the bond issue since the bond has been posted, but I am going to sign an order transferring the case to Judge Lerner Wren's division so that Mr. Henry can get in front of a division judge as quickly as possible sometime this week to address these matters. All right. Thank you, Mr. Henry. Okay, next will be Corvant Smith.
He's approaching, Judge, here at Maine.
Thank you. All right, good morning, Mr. Smith.
Good morning.
Mr. Smith, you're before the court this morning on a traffic capias. This is related to a charge for operating without a valid license. I find probable cause. And Mr. Romero, what does Mr. Smith want to do today?
Judge, Mr. Smith is requesting a straight ROR.
Well, based on the fact that this is a capias, I'm not going to grant that request. Anything further?
No, he's repeating the request for a straight ROR, Judge.
Okay, well, I'm gonna leave the bond in place that was set by his division judge, and he can make that request to the division judge. Thank you. Good luck, Mr. Smith. Next will be Scott Turnbull.
He's approaching, Judge.
Thank you. Good morning, Mr. Turnbull.
Morning.
You're before the court this morning on 4 charges. Count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with damage to property or person of another. Count 3, leaving the scene of a crash involving damage to property. Count 4 is failure to use due care. That is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, unfortunately, Mr. Turnbull is not in a position to contact anyone that can post his monetary bond. My understanding, he's a registered voter here in Broward County. He works here, and he lives here specifically in Sunrise. He's been residing here in our community for the past 2.5 years. We're asking if the court would consider releasing him on pretrial release.
Okay. Mr. Linder?
I have no objection to that with random testing, Your Honor.
All right. Okay, so Mr. Turnbull, I'm going to ROR you on counts 1 and 2. You're going to be released to pretrial supervision. As a condition of your release, you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that, sir?
Yes.
All right. Additionally, though you're going to be released today, you're going to have to report to pretrial supervision in person within 24 hours. Mr. Romero has given you a piece of paper with some of that information on it. I just need for you to understand, if you fail to report to them as you've been instructed, a warrant will be issued for your arrest. Do you understand that?
Yes.
Okay. Thank you very much. Good luck. Matthew Mitchell.
He's here.
Thank you.
Judge.
Good morning, Mr. Mitchell.
Mr. Pierre?
Mr. Mitchell, you're before the court this morning on 3 charges. Count 1 is possession of or displaying a canceled, revoked, or suspended license. Counts 2 and 3 are civil writs of arrest. Those are not for magistrate. They are in relation to child support matters. I will read the amounts on those just so that you're apprised of them, Mr. Mitchell. On count 2, for that writ, the purge amount is $1,590. And on 3, the purge amount is $1,579. I find probable cause. Do the parties wish to be heard on count 1?
One moment, Judge.
Okay.
Judge, our only request is, I just explained to Mr. Mitchell, counts 2 and 3, there's nothing this court can do. Those are the purge amounts. However, on count 1, it's a $25 bond. Mr. Mitchell is going to have to contact someone to come up to deal with the purge amounts. Considering, so we're going to be over $3,000 with the court considering ROR on count 1.
Yeah, what's up?
Does the state wish to be heard? No, Judge. All right, I'll grant the request for the ROR on count 1. All right. Thank you. Gerald Dennis.
Mr. Dennis, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Dennis.
Yes, ma'am.
Mr. Dennis, you're before the court this morning on 3 charges. Count 1, carrying a concealed firearm. Count 2, resisting an officer, obstructing without violence. Count 3 is a felony probation violation, which has a no bond hold. I find probable cause. And Mr. Dennis, I do see you're going to have a hearing with your division judge tomorrow morning to address the violation of probation matter. In light of that, do the parties wish to be heard on count 1?
No, Judge, just a photo order.
All right, I'll sign the photo order and I'll leave that bond in place. Thank you. Kyron Jones.
Please approach the judge.
Thank you. Good morning, Mr. Jones. Mr. Jones, you're before the court this morning on 3 charges. Count 1, operating without a valid driver's license. Count 2, possessing an obscured tag. Count 3 is a felony probation violation, which has a no bond hold. I find probable cause. And Mr. Jones, I do see you're going to have a hearing with your division judge tomorrow morning to address the violation of probation. Do the parties wish to be heard on count 1?
No, Judge.
All right, I'll leave that bond in place. Thank you. Abraham Weiskopf.
Come on up, Mr. Weiskopf. He's approaching, Judge.
Thank you. Thank you. All right. Good morning, Mr. Weiskopf.
Good morning.
Mr. Weiskopf, you're before the court this morning on 1 charge of burglary of an unoccupied conveyance, unarmed. I find probable cause, and I will hear from the parties. We'll start with the state.
Look him up in the system, Judge.
All right, Mr. Romero, do you want to go first while he's getting his
Judge,
information?
Mr. Weiskopf unfortunately is financially indigent. He's homeless. He did give me as a mailing address. It would be of his mother who resides, I believe, in North Miami Beach. He's 20 years old, been here his whole life. He's requesting to be released on pretrial release.
All right.
To bring the court's attention, in 2017, wait a minute. Your Honor, I'm showing he has an open grand theft and trespass out of Dade County right now from last year, an open theft out of Dade County from this year. Another theft open from Dade County last year. State would be opposing release to pretrial. Based on just his open cases alone, I'd be requesting a $3,500 bond.
All right, I'm gonna set the bond at $2,500. There will be an order of no return as well as no victim contact. Mr. Weiskopf, so that you understand the no return and no victim contact orders, the no return order means that you are not to go to the location that is at issue in this case. And with respect to the no victim contact order, whether you know the alleged victims or not, That order means no being in the same place at the same time, no phone calls or text messages to these individuals, and no third-party contact or social media contact with these individuals. Do you understand that, sir?
Do you understand?
Not really. Can I say something, Your Honor?
Not about the facts of the case, sir.
I don't really understand. I'm just saying I'm innocent.
All right, Mr. Weiskopf, I just need I need to know that you understand the orders that I just explained to you.
Say it again, miss.
Okay, the no return order means that you are not to go to the location that is at issue in this case. If you need the specific location, then you can discuss that with your attorneys after today. And the no victim contact order means that you're not to have any contact with the alleged victims in this case. Do you understand?
Yes, ma'am.
All right, thank you. Malcolm Gordon.
Mr. Gordon, come on up. Oh, wait. No, he says,
Was he removed
no,
from
he's
the
not here,
docket?
right? Oh, he's here? No,
that's not him. No, this ain't no paperwork.
Was Malcolm Gordon taken off the docket?
Okay. Shouldn't have been.
Yeah, I'm just saying.
Yeah, no.
Did they have him at Maine or not?
No, they didn't pull him, Judge.
He's on, what
On
page?
the docket, it says no paperwork.
Says no
18.
paperwork, but we all paperwork.
Oh, do you want me to?
I do.
Yeah.
Okay.
How do you drive?
Okay, so we can reset it for the afternoon. So am I gonna get this packet again during the afternoon? Okay, that's fine. All right. Ladies, will you hold this for me this afternoon? All right, so we're gonna reset Mr. Gordon to the PM docket.
No problem, Judge.
All right, so next will be Nick Pierre.
Approaching Judge in Maine.
Judge, I have a brief argument, count 6.
Okay. All right. Good morning, Mr. Pierre.
Good morning.
Mr. Pierre, you're before the court this morning on 7 charges. Count 1, possession of cannabis greater than 20 grams. Count 2, possession of cocaine. Count 3, possession of alprazolam. Count 4, possession of PVP. Count 5, resisting an officer, obstructing without violence. Count 6, burglary of an unoccupied conveyance unarmed. And count 7, fleeing with disregard of safety to persons or property. And Mr. Miller, I will hear your argument at this time.
Judge, I would just argue that count 6 is an attempt.
Okay,
It is.
all right. That's fine. I do see that in the probable cause affidavit. So I'll just make a note of that on the finding sheet. All right, I find probable cause, and I will hear from the parties.
One moment, Judge.
Okay.
Requesting a $1,500 bond on 6, $3,500 bond on 7 on the second-degree felony. His priors include resisting without violence and reckless driving, 2015, robbery by sudden snatching, 2015, resisting without violence, 2012, resisting without violence, 2012. Nothing further.
Mr. Romero?
Judge, Mr. Pierre already tried to reach out to his girlfriend. His girlfriend is, she's working, she's a bartender, has limited resources. Now, Mr. Pierre's been here his whole life. He's 27 years old. He was working for a push management company where it promote different items. He's been doing that for about 4 years. His pay varies depending on the work he gets, but it can be anywhere from $15 to $20 an hour. Now, he lives in Oakland Park with his parents. Judge, and most, his girlfriend, using the service of bondsman, is going to be able to come up with, if the court would set a total of $4,000 bond. So we're going to be requesting on count 6, a $1,000 bond. We're going to be requesting on 7, a $1,000 bond. On the misdemeanor, which is count 5, we're requesting this court consider an ROR. On count 4, the possession of PVP, we're requesting the court consider an ROR. And on count 1, the cannabis offense, we're requesting an ROR. So we're going to be requesting on counts 2, 3, 6, and 7, a total $4,000 bond.
Bond on count 6 is going to be set at $1,500. The bond on count 7 will be set at $2,000. On count 5, I will grant an ROR. And I'm going to leave the other standard bonds in place. Thank you. All right, next will be Kyle Bessett.
Mr. Bissett. He's approaching, Judge.
Thank you. Good morning, Mr. Bessett.
Morning.
You're before the court this morning on one charge of grand theft auto. I find probable cause, and I will hear from the parties.
Nothing requesting by the defense, Judge.
All right, anything from the state?
One moment, Judge.
Okay.
Let's see what it's for. No, it's not that. Your Honor, I'm requesting a bond increase to $3,500. Mr. Bissett was arrested February 28th for possession of cocaine, heroin, and drug paraphernalia. He just posted bond and was released last Wednesday.
Confinement is advising me that he's going to be ad charged because those bonds have been surrendered.
And Judge, Mr. Bissett did advise me of that, but unfortunately, from what he said, he basically his girlfriend spent all his money bonding him out, and she really has nothing else. But I've advised him, considering the totality, we didn't have any requests at this time, Judge.
Nothing further.
All right, the bond is going to be increased to $2,500. Thank you. Pedro Reynaldo Gomez.
He's approaching, Judge.
Okay. Good morning, Mr. Gomez. Mr. Gomez, you're before the court this morning on 3 charges. Count 1, driving while license suspended, third or subsequent offense. Counts 2 and 3 are felony warrants for violations of pretrial, which have no bond holds and are not for magistrate. I find probable cause. Do the parties wish to be heard on count 1?
No, Judge.
All right, I'll leave that bond in place at this time. Thank you.
Judge, may I advise the defendant that he is due for arraignment on his other case on the 14th?
Okay.
14th, that's not right.
Not right.
One moment, Judge.
Saturday.
18th, sorry, Judge.
On the 18th. All right. So he's got an arraignment hearing set for March 18th. Okay, next will be Gustavo Romero.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Romero. You're before the court this morning on 3 charges. Count 1, resisting an officer obstructing with violence. Count 2, resisting an officer obstructing without violence. Count 3, trespassing on an unoccupied structure or conveyance. I find probable cause, and I will hear from the parties.
Judge, Mr. Romero advised me he's not working at this time. He lives in Tamarack with his parents. I'm going to be requesting a $1,000 bond on count 1, Judge, and a photo order as well.
I'm fine with that, Judge.
All right.
Also ask for an order of no return.
Okay. All right. The bond on count 1 will be set at $1,000. I will sign the photo order that was requested. There will also be a no return order. Mr. Romero, so that you understand that no return order means that you're not to go to the location of the trespass. Do you understand that?
Yes, ma'am, I do. Thank you.
All right, thank you. Good luck. Okay, next will be Dakota Fishman.
Bonded.
Okay. Jairus Ricard,
That's a refusal, Your Honor.
he's a refusal. I see he was reset throughout the weekend.
Shall I? Well, Judge, it is a PBL. I don't
I
feel
see.
comfortable waiving his presence.
Well, he's waiving his presence, Your Honor, by refusing.
Were the resets over the weekend, were those refusals or were those medical resets?
He came in this last Saturday and Sunday.
They were, let me go to North Broward. They were both refusals?
Yes.
All right. Well, Mr. Miller, does the public defender's office represent him for anything?
Judge, I'm checking now.
Thank you.
Judge, last time we represented Mr. Ricard was in 2011.
All right. Because this is a PBL case, I will give him one more opportunity to join us. If he is not with us tomorrow, then we're going to proceed without him.
Understood, Your Honor.
All
Thank
right.
you.
Thank you. All right, that brings us to the end of our morning docket, so I'll see everyone back here at 1 o'clock for the afternoon docket.